Welcome to part 2. Here we're going to talk about powers of attorney, financial and healthcare documents. These are very important for us to pay attention to. One thing that's also very important, many people think that a will is part of the trust. It's not. A will and a trust are separate documents. Many people think that their powers of attorney are part of the trust. They are not. They are separate documents. Each of the different types of documents that I'm going to talk about in the next few minutes are separate documents, and they're separate from the trust. They're part of what I call a trust or a will package, but they are indeed separate documents. Let's look at the financial durable power of attorney. What you want to do is nominate somebody, that person is called your agent, to be able to take care of things while you are alive for assets that are not in the trust. Why would you do that, you think? Because I put everything in the trust. Yes, you might have been one of those people that dutifully put everything into the trust. But let's say that you're now in a coma by reason of an automobile accident, and the automobile accident was caused by someone else. Keep that in mind. You can't sign documents now, right? And you could not put your right, your lawsuit right against this person that ran into you into the trust because it just happened. So this is outside the trust. There are many other things that would be as well, and I'm using this only as a single example. So you do need to have, as part of your financial and estate planning, you do need to have a financial durable power of attorney. Why do I emphasize the word durable? The reason is a normal power of attorney, that is non-durable, will cease to operate when you become incompetent. When you are in a coma, you are incompetent. So just when you need it most, it will not work. You need to have the proper document for the proper job in it. In this case, the proper document is a financial, durable power of attorney. And again, this covers things not in your trust. In fact, it even allows this person who holds this power to put things in the trust. For example, you forgot to put in a piece of land or something. Well, while you're in the coma but still alive, your agent can actually sign a deed that puts your property into the trust, thereby avoiding a probate. Very important document. This person can make financial decisions for you, and they can actually sign your name to documents, such as the deed. There are two different types of powers of attorney. One type is called a springing power of attorney. What this type of document says is, I appoint so-and-so, let's make it Joe, I appoint Joe to be my agent. Now, the nomenclature here is I'm the principal because I'm creating the power. The person acting is my agent. So I, the principal, name and authorize Joe, the agent, to be my agent under the durable power of attorney. But not until I become incompetent. In other words, this power of attorney does not take effect until I'm incompetent. And that's why we call it a springing power, because it springs into power at the time of your incompetency. The second type is the instant you sign the document creating the power of attorney, that person is able to act on your behalf. Which should you have? Well, among attorneys, there is a difference of opinion as to this. Many attorneys think you should have a springing type. I'm one of the attorneys that say, no, you should not have a springing type. You should have it effective immediately. And the reason you should have it effective immediately is, at the time that you need it, you don't want to be arguing with somebody over whether or not you're incompetent. Sometimes, to determine the competency, you're going to end up with a court proceeding simply to determine the competency to see if the springing power has now sprung into use. So, I'm of the opinion you should have it effective immediately. The argument against that is that people say, well, what would happen if the agent decides to cash me out and move to Rio for the carnival? And my answer to that is, you have to pick somebody that you trust. And if you don't trust them when you're competent, then I don't think you should be trusting them when you're not competent or when you're in a coma. You've selected the wrong person. You need to select someone you can trust who can act immediately in the event that it ever becomes necessary. Probably some people watching this have older powers of attorney. By that I mean older than 1998. In Arizona, there was a significant law change in financial durable powers of attorney in 1998, and I think you really should have that updated to the modern law. Again, these are like spare tires, and you can feel perfectly fine driving from Phoenix to Yuma with a flat spare tire, so long as you don't need it. It's only when you're between Gila Bend and Yuma, a 100-mile stretch of pure desert, when you have a flat tire and find you have a flat spare tire, that you would find that this is not good. So documents are important, and they have to do their job at the time that you need them. Merely feeling good is not going to carry it. I'm going to switch here to healthcare. There are several healthcare documents that we need to talk about. The first of which is most famous, and that's called the living will. All states have a living will statute. Technically, this is called the Directive to Physicians. And everybody signs these by the millions. People across the country have signed these documents. And the essence of what they say is, if I'm green around the edges, pull the plug. Well, I've got some bad news for you. The Directive to Physicians is virtually useless. So, like the flat spare tire, it is not the document you need at the time that you need it. Let me give you 3 quick scenarios to explain why it is useless, because normally people will get all upset when I say this. Then I'm going to talk about a document that actually works, the document you will need, and something that is should be part of this quiver, so to speak, of your estate planning documents. Now, example 1. Your mind is in perfect shape, but your body is falling apart. So you check yourself into the nearest emergency room, and they take one look at you and they say, good grief, they sound all the alarms. People show up from everywhere. They put you on a gurney, take you to a room, hook you up to every machine known to mankind, and they say, we don't know how you made it here, but you're never leaving this room ever again. Disconnect any one of these machines and you die. So you think about this. You have a little bit of the hospital food, and you make your decision. You say, I am not going to live the rest of my life like this. So you say to them, please bring me the papers to sign. I'll sign them, and you can withdraw all this material and this life support equipment and just let me go. Your mind is fine. That's not the problem. So they bring you all the papers. You sign it. They withdraw all the documents. They withdraw all the equipment, and you die. Who bore the ultimate responsibility there? The answer is you. When you signed those documents, you were the one making the decision for life and death. You chose that you didn't want to live this way, and you died. Number 2, you've got a living will. It says, pull if green around the edges. The doctor comes in, you're unconscious, looks at the chart, goes over to the wall, and says, well, it says here I'm supposed to pull, and if he's green, looks green to me. Now here is the serious part. If they leave you on the machines, now we all know how good these machines are. You're going to live another 5,000 or 6,000 years, right? But if he pulls the plug, you die. Moment of truth. Doctor looks at the chart. Pull plug if green. Looks at you. You're green. Pulls the plug. You die. Who was the operative cause of your death? The doctor. And what do we call people who are the operative causes of death of people who would otherwise have lived 5,000 or 6,000 years? Murderers. Wow. You suppose the doc wants to pull the plug? If you were the doctor, would you pull the plug? Probably not. Well, I've got some good news. In some states, such as Arizona, the doctor is protected by law, but not true in all states. And this is from criminal law, right? The murder. Suppose some kid comes out of the woodwork and says, "Oh yeah, doc, I know you're supposed to pull on green, but that was the wrong shade of green. Dad was talking emerald green, and this was a pastel green, so therefore, at best, I think you're guilty of wrongful death and malpractice." Could a kid pull that kind of a thing? Probably. Not a good idea, though. Arizona law, again, will protect the doctor. But you might not be in Arizona when this happens. So, when I say a directive to physicians is virtually useless, that's what I mean. Let's look at a document that works. This not only works in all 50 states, Canada has now adopted these. It's called the Healthcare Durable Power of Attorney. Remember, a power of attorney dies when you die, financial or healthcare. A power of attorney becomes ineffective or void when you become incompetent, unless it is a durable power of attorney. So, particularly in healthcare, we need to have a healthcare durable power of attorney. And very much like the medical power of attorney, this allows someone else to come in, make decisions for you, and sign your name. Well, what's the implication of that? And the answer is scenario number 3. Remember, I told you I was going to give you 3 scenarios. You're back in the hospital bed again in this coma. You can't sign documents. The doctor won't recognize your living will. What happens? Fortunately, you now have a healthcare durable power of attorney. Your agent comes in, looks at you, now has the power to call for the papers and sign your name. So when that plug gets pulled, the ultimate responsibility is back again on your shoulders, not on the doctor and not even on the agent, because they are acting under your authority. That's why the healthcare durable power of attorney works and the other one doesn't. All states have 2 documents, the ones I just mentioned. However, in Arizona, we have yet a third one. In fact, we have 4. This third one is called the Orange Sheet. It was developed at the University of Arizona. It was a coordinated effort between the University of Arizona Medical School and Law School. And it's technically called a Pre-Hospital Medical Care Directive. But in real life, we all call it the Orange Sheet. 4 other states have now adopted this. Well, I shouldn't say that. 4 states now have this. Arizona originated it. 3 other states actually followed. New York, Colorado, and Florida. So the Orange Sheet is going to be valid in any one of those 4 states, but it is not going to be valid in other states. What this does, the Orange Sheet, is it directs the withholding of care rather than authorizing the withdrawal of it. Withholding versus withdrawal. So in other words, instead of having your agent come in and say, remove the life support equipment, the Orange Sheet says, never hook me up in the first place. There are times when you would want this, but not often. For example, if you were told by your doctor you had some dread disease and were given only weeks, days, months to live, you might appropriately want to sign this so that if for any reason you became unconscious, you would not be brought back to consciousness simply for the purpose of suffering. But if you don't fit into that category and you're in a car accident and the emergency teams arrive and their heart's not doing well and they know they can hit you with a defibrillator and you'll be fine the rest of your natural life, if you have signed an orange sheet and if the paramedics know you've signed the orange sheet, then they're not allowed by law to hit you with a defibrillator and you'll die right there on the street. My advice is, unless you're in that specific condition of a known terminal illness, I don't advise people to sign these, but they are one of our 4 documents. The next document, and this is the 4th of the healthcare documents that we have in Arizona. No other state has this. It was developed here again at the University of Arizona. Under the mental health power of attorney, you name an agent who can, in essence, lock you up in a level 1 mental facility. Absent having this, you are required to go through a court proceeding and obtain special court authority for your guardian. We're back into healthcare, so this is the guardian side of the guardianship and conservatorship. The guardian must have special authority to place you in a level 1 facility. Going through the court proceeding not only takes time, which is quite important if you happen to be, say, dazed or have some dementia and you're going to, without this, going to be walking off into the desert or across the freeway, but it's also very, very expensive because you have to have different types of medical reports and neuropsychologists and things like that. So the University of Arizona came up with a mental health power of attorney that avoids having to do all of this and literally saves thousands upon thousands of dollars. But by the time it got to the legislature, it had a couple of interesting quirks that I have to point out. While your agent can lock you up, the legislature said you can either make it revocable or irrevocable. Well, I always thought that was rather interesting, because if you made it revocable, then you normally, while you're competent, you could revoke it. Well, that's fine. Everything else you do should be revocable. Situations change, times change. You should be able to change things along with it. That's why revocable documents are good. But the legislature said, well, no, in addition to that, because you might be goofy, you might want to revoke it when you shouldn't. So you should be able to make it irrevocable. This leads us, the way the statute's written, and no case that I know of has interpreted this, it leaves you with a rather interesting thing that you can be Looney Tunes and revoke, but you can be perfectly fine and not revoke. So what do I recommend? I recommend you have a mental health power of attorney, but make it revocable. After all, at the time that you need it, most likely you won't even know you have it, so therefore you can't revoke it. You won't know any of the other things that are going on either. But if you make it irrevocable, it says that you can't revoke it even if, for whatever reason, you had a falling out with the agent. So I think that it's a bad idea to make anything irrevocable. Make it revocable, and then you won't have any problems. There's another thing that we've all put up with called HIPAA. It's not hippo. You see, that's why I put this big hippopotamus there. This HIPAA is the HIPAA, which is the Health Insurance Portability and Accessibility Act. Originally passed in 1996, it was for privacy, but the problem is there were no regulations dealing with it until 2003. April 2003 came a whole group of regulations, and if you'll scratch your head and go back about 10 years, you probably remember all your doctors and dentists were saying, please sign all these new forms. and that was because of HIPAA. One would think that if you have granted to someone the authority to pull the plug and in essence kill you, that along with that impliedly would be the authority to see your medical records and obtain the information on which to make a medical decision. Does that make sense? Made sense to everyone except the government. By 2003, they decided, yes, you can pull the plug, but no, you cannot have the information to base it on, because of HIPAA. So now what you have to do is have specific authorization. Well, these are generally also the specific authorizations generally written into the newer, by new post-2003 healthcare documents. I think it's also a good idea to have a shorter version of this, of a release of information, so that your agent can be able to obtain any of the information that's needed to make a healthcare decision, even if, no matter what it might be. So definitely I use those as an additional document. Again, separate from the other documents, but it is all part of the package of estate planning that you really should do. Many people would like to donate an organ. And in the old days, you'd put it on your driver's license, and that's not a good idea, even in those places where it's allowed, and it's no longer allowed here in Arizona. What you should do is make direct contact with a medical school or with one of the other organizations, such as the Biological Resource Center or Donor Network of Arizona. They have some advantages, by the way, that you might not know about. Let's say that you contact one of them. Now, the med schools I don't think do this, but I do know that the other organizations do. And you fill out their paperwork, and then upon your death, what they will do is come pick up your remains. They take the remains, they do some medical testing to make sure you don't have some dread disease that's going to infect all the medical people dealing with it. Then they check to see if there's anything that is usable. For example, they really love bankers. Because they can use their hearts for transplants because their hearts have never been used. But other people have brains and other things that even if they can't be used for transplant, they can use them for research. Once they are done with that, taking out, they call it harvesting, taking out whatever they can use, they then will cremate what are the remains, and they will give the ashes to the person that you designate. Total cost to you is zero. So it does have a very good financial aspect to it, in addition to the fact that you are helping science.